Welcome to the Hughes Hubbard Anti-Corruption and Internal Investigation Practice Group's podcast, All Things Investigations. The Hughes Hubbard Anti-Corruption and Internal Investigation Practices Group represents many of the premier companies around the world, providing advice on issues spanning the full anti-corruption and compliance spectrum. In this podcast, host Tom Fox and members of the Hughes Hubbard Anti-Corruption and Internal Practice Group will highlight some of the key legal issues involved in white-collar and other investigations, both domestically and internationally. We will tackle topical issues involved in investigations, as well as explore how companies can prevent and detect issues that arise in conducting investigations on a worldwide basis. Today, I'm joined again by Tom Lee. Tom is special counsel with Hughes Hubbard & Reed. We're going to take a deep dive into the Loper decision, which invalidated the Chevron Deference, and consider how companies should approach Chevron Deference issues with regulatory agencies and departments going forward. With current events, as I have special counsel Thomas Lee, or Tom Lee, as I'm going to call him, throughout this podcast. Tom, first of all, welcome back to the podcast.
It's a great pleasure to be here again, Tom.
Tom, this was as momentous a Supreme Court term as we've had, although perhaps every term is momentous. But one of the momentous cases was the Loper case, and that did away with the Chevron defense. And you've written a client alert, which we're going to link to, but I wanted to maybe explore the parameters of the decision and then some of the questions you're already getting. So if I could maybe start by asking you to tell us a little bit about the case and the Supreme Court's decision.
Yeah, so there's something that lawyers refer to as Chevron deference. Many times Congress enacts a statute that seeks to regulate a particular subject matter. The cases at issue in the Loper Bright case involved certain rules regarding the fishing industry. Congress enacts law. They're not incredibly specific about certain details that are in the law. And so the Chevron decision in 1984 said, look, if you have something in a statute where the understanding of the particular terms is ambiguous, and in the statute at issue in Chevron, it was stationary source, whether, the EPA, when it sort of determines who a polluting stationary source is, it one smokestack as opposed to the entire factory, that makes a big difference. And so the Supreme Court said, look, if the words are ambiguous, then the administrative agency that's charged with enforcing the law the court should give them the ability to engage in reasonable interpretation. So long as the interpretation of the key terms is reasonable, the court should just defer to that. And that's so-called Chevron deference. And it was the law of the land for 40 years or so until this past term, as you said, Tom, the Supreme Court overruled Chevron deference and said, look, if you come to one of these forks in the road where there's some ambiguous words in the statute and you think the agency has given you a reasonable interpretation, the courts cannot defer to that reasonable interpretation. They have to independently consider what they believe the meaning of those words to be. And even if they think that the agency got it wrong, but reasonably wrong, they can't defer to that at all. In formal terms, that seems to be a really big change. But the reality is, for the past 10 years or so, there had been this suspicion that Chevron was not on firm foundations. And so courts had figured out various different ways of trying to not rely on that particular deference. They would say something like, these terms are not ambiguous, right? Or they'd say, look, even if they were ambiguous, the agency's interpretation is what we consider the best interpretation anyways. So there's all this hedging around Chevron because people thought it was unstable. And now the Supreme Court has essentially said Chevron deference is no longer available. The second point I'd like to add about that, Tom, is the Supreme Court didn't say that Chevron deference was unconstitutional. They didn't say that, it would be a violation of Article III courts' constitutional responsibilities to allow agencies to determine law in this way. They said that basically Chevron deference is inconsistent with the Administrative Procedure Act of 1948. So it was a statutory holding, not a constitutional holding. Justice Thomas believed that it was a constitutional rule. And Justice Gorsuch indicated sympathy for that, but they were the only two who sort of made that position clear. So it's an interpretation of the statute, not the Constitution, to say that courts have to defer, they can't defer to legal interpretations by agencies, even if they're reasonable.
Tom, I really appreciate those 2 points because that really communicates to me and hopefully to our listeners that this is not sort of radical justice making out of left field that we've not considered before. It's a series of decisions leading up to, but grounded in the Administrative Procedures Act, which is old enough that even I studied that in law school. I guess sort of point one is, I don't want to say no big deal, but I want to say that perhaps we saw it coming, and perhaps people like yourself who play in this arena have thought about the consequences. So maybe if I could ask you to turn to some of these consequences, what happened to all of the cases decided under Chevron over the past 40 years?
Yeah, so that's a very important question. And Chief Justice Roberts, in his opinion, attempts to say, look, if it was a situation in the past 40 years where the court relied on Chevron deference, it doesn't mean that that case gets automatically reversed. He uses the term statutory stare decisis. And I'm going to quote from the opinion. I think that's the best way to sort of understand what he's trying to do here. So he says, look at, and I'd explain to you the provisions of the Clean Air Act regarding stationary source, right? So he says, this is a direct quote from Chief Justice Roberts' opinion for the majority, open quotation, "We do not call into question prior cases that relied on the Chevron framework." Close quotation, open quotation, "The holdings of those cases that specific agency actions are lawful, including the Clean Air Act holding of Chevron itself, are still subject to statutory stare decisis despite our change in interpretive methodology." Close quotation. So if you were on the losing end of a court decision because of Chevron deference, you don't get an automatic do-over, right? And, you know, there's no way procedurally you could say, that sucks for me, I should be allowed to reopen that judgment. I mean, that is decided. What could happen, and this is interesting, and in my client alert, I mentioned the holding 3 days later in another case, very important case, Corner Post Incorporated versus Board of Governors of the Federal Reserve System. They construed, and this is why the Administrative Procedure Act is important again, they construed the 6-year statute under the APA as a discovery rule. That means that if you want to challenge a regulation under the APA, you have 6 years from when you discovered when the regulation applied to you, even though it was unconstitutional, or strike that, even though it was unlawful. And so it's not 6 years from the date that the regulation was made. So consider the possibility that you have some newly formed entity and they want to challenge the definition of stationary source, right? So presumably they could do that because they're still under the statute of limitations. And now we have this guidance saying that, look, when you look at this interpretation, you're not bound by a reasonable interpretation. Presumably, you know, you could go ahead and challenge that. Now, what would that challenge look like? You could try to challenge preemptively and say, look, we're considering going into this line of business that the regulation would affect, and we want a declaratory judgment. But that's probably, I mean, there's some complication there. I mean, what you could do is, I mean, and you'd have to consult lawyers, you'd have to go about doing your business, and then when the government comes after you, when the agency comes after you, citing that regulation, and you could sort of defensively say the regulation's determination of the key interpretation of the key terms are not what the court should decide, right? And presumably you can relitigate it that way. And so when Justice Roberts, the majority, in those two sentences says, look, we're not saying you get a do-over for all the past Chevron deference holdings. I mean, he can't get out of this that easily, because the reality is now the rule is it has to be the best, the court has to determine the best interpretation, not that it's a reasonable interpretation. And presumably you can still litigate that if, you know, you have the statute of limitations and it's statutory stare decisis. It's not, you know, there's nothing precluding you as a matter of precedent from bringing the case on your own.
Tom, how about prospectively? And this is the one that I just see as almost a five-dimensional chess game. And I don't know how you've thought through it, but whether you're an individual company, whether you're a trade organization, whether you're some combination of both, how do you begin to think through? And of course, we have to throw in venue, we have to throw in courts of appeals, and lots of other factors. I assume you've begun to get these questions, and how are you helping companies at least have a framework to think through them?
Yeah. So the first is to identify regulations that you think are going to be unstable and challengeable in this current environment, right? In a different part of the opinion, which I mentioned also in the client advisory, I said, look, Chief Justice Roberts for the majority said, just because you don't get Chevron deference, it doesn't mean that when the agency comes up with the interpretation, you can completely disregard it. He talks about respect. Interesting. Not deference, respect. Sometimes you have to give respect to agency interpretations. So when might you have to give respect? He says, look, if it's an old statute and the agency regulation was contemporaneous with the statute, maybe that's a situation where you get respect. If the agency has been consistent about an interpretation for a very long period of time, maybe that's a situation in which you give respect, right? If there are words in the statute, not generic, the agency has the authority to promulgate regulations as necessary to enforce the statute. That kind of language is in a lot of statutes. But if you have some specific language that gives the agency the power to define or delimit and as necessary appropriate, and he's very unclear about what those words have to be, but if the statute contains some language saying that Congress is delegating to the agency some specific authority to define key terms, then maybe you still owe respect. And so that is going to be a huge subject of litigation, I would assume, right? I mean, people are going to look at a regulation and say, you know, it has this language. Is it going to be language that sort of affords a permissible delegation or not? So those are three situations that you'd think about. So if you see a regulation, it's relatively new. It's contrary to what the agency had said for a very long time. And there is no language that seems to give special authority to the agency to promulgate the regulation, then that looks like something that you should be challenging. And as an example, under the Securities Act and Exchange Act, 33, 34 Act, they regulate dealer. And so there's a challenge going on in the Fifth Circuit where the SEC, by a recent rule, has said the dealer includes private investment funds that are making investment decisions. They're not necessarily agents to trade, but they're saying, like, look, that's within the definition of dealer. And so in that case, which is being brought in the Fifth Circuit, and this ties into what you were saying about venue, there's going to be a lot of gaming going on because the ideological balance of power on different circuits is different. The DC Circuit, President Biden put a lot of his nominees on there. So that's the usual place where you challenge regulations, but is not a hospitable environment for bringing these kinds of challenges. So you're gonna try to figure out a way to bring the challenge in a circuit that's more hospitable. But those are some of the considerations. So if somebody comes to me, I really hate this rule, I really hate this regulation, I think the agency was sort of being overly aggressive doing it, how do I challenge it? And so those are some of the things that I would advise and talk to the client about considering, right? And then, is it really worth it trying to proceed as if the regulation was invalid? Because you might lose, right? I mean, the court might say the agency's interpretation is the best interpretation. And so is it going to be worth the litigation costs? And so that's the kind of consideration and discussion that I'm already having with clients who said, I really don't like this rule, and should I challenge it on these terms, right?
Tom, can I ask you a couple of questions about the Administrative Procedures Act and what that might require from an agency and how that may play into either your analysis you would make for a client or how a court might look at a rule promulgated?
Yeah. There's a substantive piece and there's a procedural piece to the APA. The substantive piece, and Chevron is an example. So the agency takes an interpretation of dealer or stationary source, and you disagree. You think that's an unduly aggressive interpretation of the words. That's not what Congress meant. Those are substantive challenges. You're sort of challenging the agency based on the content of the regulation, or as opposed to procedural challenges, because the APA also has, notice and comment procedures for rulemaking. You have to sort of publicly announce what you're intending to do. You have to give a period of time to allow the public to sound off on it. And so if that's the paradigm, let's say the agency didn't engage in that, or they sort of did an abrupt change, right? They made sort of like an arbitrary and capricious process. It's almost like they flipped the coin to figure out how to decide the rule. So you can also make these kinds of procedural challenges, or you could say, they issued it in the form of a letter ruling, as opposed to sort of a formal process, and they can't, and so these things are not entitled to deference as a regulation. So you can make both kinds of challenges. An example, I have clients who are very interested in the Inflation Reduction Act litigation, and that's the sort of a signature piece of the Biden administration's work in Congress, this attempt to bring down prices for pharmaceutical products and drugs through Medicare. And it's interesting because the litigation focused on constitutional arguments. So they said, look, you're taking the property of a pharmaceutical company that's on the list of products that the prices have to be negotiated in, or you're forcing us to say that these are equitable prices, First Amendment. And so it was interesting to observe that they're mostly constitutional challenges. Now, I would assume that there's going to be more focus on the procedural sort of administrative regulations piece of that, right? Because one thing is clear, that this court is very favorable to anti-administrative agency stuff. So I would assume that you're going to see some pivoting and adding more of these APA type claims and sort of pointing the finger at the agency as opposed to trying to strike down the statute as unconstitutional.
Tom, the first time I had the chance to visit with you on a podcast, I thought your practice was incredibly dynamic. I can only imagine it's exponentially more dynamic now. So that leads me to really hope we can continue this conversation. I'm sure we're going to have a lot more to talk about over the next coming months, and looking forward to continuing this conversation.
It's always a pleasure, Tom. I talked too much. I hope it was informative. And as I said, it's, lawyers, we live with what we're given, right? And the environment has changed. I mean, there are tectonic shifts in the environment here. And one thing I like to think of is, at a very fundamental level, the administrative state since the New Deal sort of operated with the tailwind in the age of expertise, in the age of modern complexity. And all of a sudden, at a very fundamental level, we're sort of seeing the courts, the wind has shifted, and now there's almost a headwind against the administrative state, right? And so that's the kind of intuition that is separate from the doctrinal pieces and the challenges that you move. I tell clients that, look, there's definitely sort of a change in the environment, and it reminds me a lot of the Erie line of cases. When the Erie decision came out, that was also a sub-constitutional holding. The court purported to construe the Rules of Decision Act, but it had these constitutional overtones of, the federal courts can't do something using diversity jurisdiction to make substantive rules anymore. And so this has the same feeling. On the ground, in particular cases, you could say not much has changed because everyone knew Chevron was unstable. But at a very fundamental level, the environment has completely shifted, I feel.
Well, Tom, fortunately, we're near the end of our time for this episode, but I wanted to thank you again. And as I said, I look forward to continuing this conversation.
Thank you, Tom, for having me.
This is Tom Fox again. Thank you so much for listening to this part 2 of this special 2-part podcast series where we looked at economic sanctions and trade controls in the EU and from the European perspective. I hope you will join us again for our next episode of All Things Investigations, and that you will subscribe, rate, and review wherever great podcasts are listened to. The award-winning All Things Investigations is a production of the Compliance Podcast Network.